Good afternoon. It's the same guy every time. Welcome to the White and Case Jessup Cup World Championship match. Woo. A very special hello to several ambassadors who've joined us this afternoon at the invitation of their Jessup teams. You honor us with your presence, and I couldn't imagine a friendlier environment for you to come to for international diplomacy and international law, so you are welcome. And to our remote teams and our friends watching around the world, you've already heard me talking about going live, so you know we're live. I didn't know it was a hot mic. They said I was a hot mic. We have a fantastic championship round ahead of us with, you now know the identities, 3 amazing judges, and if I can say, 2 amazing teams. Representing the applicant today is the National University of Singapore. And representing the respondent from the Philippines, we have Ateneo de Manila University. So, in a moment, the bailiff will call all rise and the judges will come into the room. Before we do that, I want to ask everyone to turn off or set to silent mode any mobile phones, smart devices, beepers, holographic support animals, or anything else that might distract the round. Shut them down. Judges, would someone please add me to the WhatsApp group? Good luck to both teams. Have a great match.
All rise. The International Court of Justice is now in session. President Anaya and Honorable Judges Munoz and Akande presiding. The case before the court is the case concerning the Gordian Gorge. The parties are Applicant, the Dominion of Alakostria, and versus Respondent, the Republic of Restovia. The Applicant and Respondent are each allocated 45 minutes to present their pleadings.
Please be seated. Good afternoon, everybody. Council, looking forward to your presentations. We've read your memorials with great interest. So, applicant, please proceed. Please proceed.
Mr. President, Your Excellencies, may it please the court. My name is Phoebe Chan, And together with my co-agent, Ms. Tan Kai Han, and our off-counsel, Ms. Lee Don Jean, we act on behalf of the applicant, the Dominion of Alakostria. For the first 22 minutes, I will address this court on the first two issues pertaining to Selenia's intervention and the consultation of the Piliman people. For the next 22 minutes, my co-agent will be addressing you on the issues concerning Ms. Liz Scott's extradition, as well as the issue of state immunity, and we respectfully reserve 1 minute for rebuttals. To that end, we advance two main submissions. First, that Selenia should be permitted to intervene in these proceedings as a non-party pursuant to Article 62 of this court's statute. And second, that Restovia has breached its obligations under both treaty and customary international law relating to the consultation of the Piliman people for the development of the Gordian Gorge. I turn to address Your Excellencies on the first issue on intervention. We note that under Article 62, a third state can intervene as a non-party if it fulfills three conditions, namely, that it has a legal interest, secondly, this interest may be affected by the proceedings, and lastly, that its object of intervention is proper. We note that this court most recently confirmed these conditions in its 2026 judgment in the Zapadilla case concerning Belize and Honduras, with Guatemala intervening. In this particular case, Selenia, in Alacostria's view, has two distinct legal interests. One, in customary international law, as a result of its citizens' rights to the gorge, and second, in the Selenia-Restovia Plateau Agreement, which I will address in turn. Firstly, on the customary international law interest, our position is that Selenia has a clear interest in this court's determination of the customary obligation on free, prior, and informed consent of the Piliman people. Your Excellencies, we note that the respondent relies on the 1990 Gulf of Fonseca decision between El Salvador and Honduras, wherein this court stated that a general interest in the rules and principles of international law is insufficient for the purposes of Article 62. But our argument in this case stretches beyond that, and that is because this court is specifically determining whether or not this obligation has been breached by Restovia to the Piliman people. And we also note that this stems from the very recognition that indigenous peoples, as a collective, have the right to their traditional lands, here being the Piliman people. And therefore, our position...
Are the Piliman people in Selenia clearly indigenous? I mean, they're the majority in that country, is that correct?
Your Excellency, we note that they are a majority in the country, but that does not preclude them from being indigenous. What it means to be indigenous would be having a certain spiritual and connection to this land that they now refer to as the Tonga Plateau. And for 40,000 years, the Piliman people across all three states have in fact venerated the Tonga Plateau and maintained their cultural connection to this land. And for that reason, we would consider Selenia's citizens to also be indigenous to the Tonga Plateau.
That would mean a lot of people in Europe would be indigenous, right, who have long-standing connections with their countries. Is that right?
Well, Your Excellency, not quite. Our understanding of indigenous peoples would refer to the First Nations of this land, and this being the indigenous people of Pilamo in this present case. And in the example of Europe, that would potentially be the Sami people that we note span across...
How about the Scots or the Irish?
Well, Your Excellency, we certainly understand that those could also be understood as indigenous, and we would certainly be happy for Your Excellencies to acknowledge them as such. And
Counsel, following on that, would you characterize the Pilamos as a transnational indigenous people, and what concrete legal consequences will follow from that, if so?
Your Excellency, would you be referring to the recognition that the Piliman people here are indigenous?
No, I would like to know if, according to your understanding, the Pilamos is a transnational indigenous people. So, because they live in 3 different countries, and they have they share characteristics spiritual, as you said. So,
Yes, Your Excellency. The very fact that the Pilaman people are straddled across these three borders does not preclude them from being considered as a collective indigenous to the Tonga Plateau. And this is because, for instance, at Article 26 of the UN Declaration on the Rights of Indigenous Peoples, it is noted that indigenous peoples have the right to their traditional lands. And there is no artificial distinction as to who, whether or not disparaged between three states, has the entitlement to this land. And therefore, our position is that this court's determination on the scope and content of the FPIC obligation in relation to the Pilaman people will necessarily implicate Salenia's interests in its own Pilaman citizens' rights. And on that, I turn to address Your Excellencies on the second interest, which we understand Salenia to have.
Just before you move on to the second interest, so your argument is that this court, in making a decision in this case, will have to decide on legal interests of Salenia. Does that then suggest that in the absence, if we do not grant intervention, that we would be precluded from deciding this case because of the monetary gold principle?
To take Your Excellency's question in two parts, firstly, we do submit that this claim, in fact, involves all Pilaman people. And that is because Alakostra is invoking standing on the basis of an erga omnes obligation, that being the obligation to the right of self-determination, which we understand the obligation to obtain free, prior, and informed consent stems from. And on your second question, we note that in the absence of Salenia, this would not in fact trigger the monetary gold doctrine being applied. And that is because the original way in which the monetary gold principle was applied was concerning whether or not the court would have to make a predetermination on the international responsibility of an absent state. And this was, for instance, noted in the 1990 Gulf of Fonseca case, where this court considered that Nicaragua's interests, though implicated, was not going to be a monetary gold party in that sense. And therefore, our position is that Salenia, though it should have an interest and be allowed to intervene, would not preclude this court from exercising jurisdiction over the second issue. And on the Salenia-Restovia Plateau Agreement, I turn to address this interest. Now, we note that the respondent, in their memorials, attempt to draw an analogy to this court's 2001 Pulau Ligitan decision, arguing that Salenia's interest in the SERPA is not sufficiently proximate to the proceedings. While we fully acknowledge that the SERPA is not being put forth for this court's consideration, our position is that this does not preclude its interest from being affected nonetheless. And this is because it is acknowledged by the respondents themselves that the Articles 17 and 18 of both treaties are identical in text. Now, not only are they identical in text, but they also share overlapping object, purpose, and the circumstances surrounding this conclusion. And that's because in 1971, Salenia was the very state who initiated the conference with the express objective of ensuring that the Pilamans would have lasting access to the plateau. And therefore, our position is that this court, in interpreting Article 18 of the Alakostra-Restovia Plateau Agreement, might therefore influence a future interpretation of the Salenia-Restovia Plateau Agreement.
But Counsel, are there not other elements of treaty interpretation that might suggest that the two treaties could be interpreted differently?
Absolutely, Your Excellency. We do note that the parties, being in fact signatories to the Vienna Convention on the Law of Treaties, would subscribe to the general principles of treaty interpretation, which we understand to mean that each distinct bilateral treaty is to be interpreted differently. But that is not the standard for when an interest may be affected under Article 62. The threshold for may be affected is a low one, and the very fact that they may be interpreted differently is not itself a precondition to allowing Salenia's intervention. What we are saying is that the overlapping circumstances, the identical text of the provisions, and the overarching purpose of both treaties may result in this court finding a similar interpretation, and on that basis, it should be permitted to intervene. I turn then to the proper object of intervention requirement. We note that the respondents have contested within their memorials that Salenia does not have a proper object of intervention, because it has indicated its intention to pursue future litigation against Restovia. But we also note that this court, in its recent decision of the Sapadilla case, has decided that having a separate claim is not itself a bar to an application to intervene under Article 62. And for that reason, because in our view, Slovenia has clearly expressed its interest to protect the rights of its citizens, that should itself constitute a proper object of intervention, and that its intervention should in fact be permitted by this court.
But isn't there a difference, though, between those two, the case that you cite and the present one? In the case that you cite, there were already existing proceedings. In this case, wouldn't the third party be using intervention as a way of actually bringing its own claims effectively into decision in this particular case?
Absolutely, Your Excellency. Firstly, we do absolutely note that in the Sapadilla case decision, Guatemala had already submitted itself to the binding jurisdiction of a court in a separate proceeding. But in this particular case, what we are concerned with, although we do note that Slovenia has also a potential avenue of claim, is balancing the interests of Slovenia's interest in intervening and protecting its citizens and the interest of considering whether there is an abuse of process. And we note that nothing on the facts suggests that there is such an abuse of process, and even if Slovenia is allowed to intervene, it would not impermissibly broaden the scope of this dispute, because fundamentally, we are still concerned with what is in the prayer at 59B, and that is the interpretation of the Alekostra-Restovia Plateau Agreement and the determination of FPIC at custom. Therefore, we ask this court to still consider Slovenia's interest in intervening, and I move to the second issue on consultation. We submit that Restovia has violated its obligations under both treaty and customary international law. And that is because Restovia has failed to consult the Piliman people with a view of obtaining their free, prior, and informed consent. We note this to be the position reflected in Article 32, subsection 2 of the UN Declaration on the Rights of Indigenous Peoples, which was, Your Excellency.
Yes, please. I would like to explain the legal sources that support your definition of free, prior, and informed consent.
Your Excellency, we note that this was not explicitly defined in the UN Declaration, but the elements of free, prior, and informed consent, respectively, free being free from coercion, prior being prior to any commencement of activities, informed meaning that the Indigenous community is sufficiently appraised of the consequences of the project, and consent being that the state should aspire to obtain the consent of the Indigenous community.
Agent, what is the legal source for that standard you just laid out?
Your
You
Excellency.
mentioned the declaration, but that's not a treaty, is it?
Absolutely, it
If
is not.
Then what is your legal source?
We note that this has, for instance, been considered by the Inter-American Courts in the decision of UA and Colombia 2024, and is also noted by the UN Human Rights Mechanism in their report on the rights of indigenous peoples. And therefore, that is our position on the standard.
Is that expert report a source of international law?
We would absolutely support our conclusion that this court can have reference to these reports as a subsidiary means of international law or determining the scope and content of international law. And in fact, we also support this obligation with the practice of states and opinio juris. For instance, we note that in 2007, the UN Declaration was adopted in overwhelming favor by 143 states voting in favor. And this contemporarily is also supported by the practice of at least 57 states who have consultation practices. We note that amongst the countries of this world, there are around 85 with indigenous peoples. On opinio juris, then, we note that states...
Does it matter that some states voted against and others abstained?
Yes, Your Excellency. We note that the most famous objectors, including the Kansas states, being Canada, Australia, New Zealand, and the United States, all subsequently later endorsed the declaration in fact because they believed it to, although be aspirational, reflective of the standards that states should aspire to achieve in their domestic legislations. And in fact, Canada, for instance, has in fact adopted the UNDRIP Act, which customizes or which codifies this customary international law provision.
But are you considering free prior and informed consent as part of the customary law, international customary law, and if so, why? Because until now I am not clear, according to your arguments. Please.
Absolutely, Your Excellency. I understand in relation to your question, you might be referring to two distinct obligations, one being the obligation to consult with a view of obtaining consent, and one being the obligation to actually obtain free, prior, and informed consent. For the latter, we note that there are practices of states which support this rule, including Bolivia, India, Nepal, but we also note that the practice of states is not yet fully consistent, and for that reason, our submission rests on the first, being that consultation should at least be done with a view of obtaining free, prior, and informed consent. This is supported by the opinio juris of states like Finland, Estonia, Peru, as well as Bolivia and Canada.
Where's the opinio juris? Where do we find the opinio juris?
Yes, Your Excellency. These states have all articulated that the requirement of the participation of indigenous peoples in decision-making is, and I quote here, a legal requirement fundamental to the implementation of the rights enshrined in the UNDRIP. And one such example was Suriname, which stated before the Inter-American Court in 2015 that free, prior, and informed consent is an international requirement that states should adhere to when consulting indigenous peoples.
What case was that?
This was the decision of the Kalinia and Lukuno people, Your Excellency.
And the what? Sorry, could you say that again?
The Kalinia people, Your Excellency.
Okay,
What-
but are they saying that's a rule of customary international law, or are they interpreting the American Convention on Human Rights?
We do absolutely note that in the inter-American context, there is that convention, but they also make explicit reference to the UNDRIP and international standards of customary
But
international
aren't they
law.
referring to the declaration to interpret the American Convention? Isn't that what they're doing in those cases?
Well, yes, Your Excellency, that is part of their decision, but with respect to the reasoning of the judgment, we can also have reference to the fact that the Inter-American Court has on multiple occasions looked to the standard at customary international law. And what our position is that this obligation is one of process. This requires that the state consult the indigenous community.
Excuse me, Counsel, and how the Inter-American Court decision can be applicable for this court. And my second question is about, because it's not clear to me if you are considering that they are an international obligation to consult or to consent. Mm-hmm. And I would like to listen more and justify, because this is an important point for
Absolutely,
this court.
Your Excellency. To firstly clear up the confusion, our obligation is one which requires the state to consult with a view of obtaining consent. This is not a right to an outcome, but one to a process. And on the judicial decisions of the Inter-American Courts, we note that they are a subsidiary means of interpreting the law as noted by Article 38(1)(d) of this court statute. And if I could provide some clarity on what exactly this obligation entails, it requires, firstly, that information be provided and made accessible to the indigenous community. Secondly, that genuine dialogues happen. And thirdly, the dialogues happen with an aim of obtaining free, prior, and informed consent.
Counsel, I think we're fairly clear on your argument about the content of the standard, but the source, where do we get a legal standard? You cite to jurisprudence of the Inter-American Court, they're interpreting the American Convention, aren't they? Aren't they interpreting a treaty? So where do we get a customary rule, as you're arguing? Is the practice you're referring to simply the adoption of the declaration? Is that the practice?
No, Your Excellency, we're not simply citing one case, but rather our position is that this is in fact a distillation of the principles that multiple courts have used in order to determine whether the state's obligation has been fulfilled. So we don't just rely on the Inter-American Court's practices, but also the African Court on Human and People's Rights, which we also note is also interpreting a convention, but also the federal court decisions of Canada, as well as New Zealand and
Interpreting the
Australia.
Constitution of Canada, right?
Well, Canada does in in fact have the UNDRIP Act, which is meant to reflect the provisions of the UN Declaration on the Rights of Indigenous Peoples, Your Excellency. And if I could perhaps refer this court to a decision by the Inter-American Court once again, in the 2024 decision of UWA and Colombia, there the court had considered that although the state required that the company perform its obligations with respect to the community's integrity and access to the land, in that case, it had also set up opportunities for dialogue between the state and the community, but nevertheless, the state was considered to be found in breach of its obligation. And that was because it had essentially been embarking on a predetermined plan to exploit the land, and therefore it was not, in fact, a genuine dialogue aimed at obtaining the consent of the indigenous community. And we draw an analogy to this present case, where we say Restovia failed to do three things. It failed to provide information, making it sufficiently accessible to the community. It failed to properly engage in meaningful dialogues. And finally, it failed to actually obtain or aim to obtain the consent of the community. And Your Excellencies, I point you to a few salient facts, being that, yes, we do note that there were documents provided, but these were thousands of pages of technical...
Excuse me, Counsel, I'm extremely interested
Yes.
in better understand which exactly human rights or people, indigenous people rights, are affected by the consultation process, according to the facts of the case. Are there only spiritual and cultural aspects, or they are also aspects related to environment, for instance, in the context of climate change, future generations? Could you explain more about this?
Absolutely, Your Excellency. We note that the free, prior, and informed consent obligation is a procedural right aimed at guaranteeing the substantive right of indigenous peoples to, for instance, their right to culture, their right to use and enjoy land. I note my time, Your Excellency, if I could have 30 seconds to conclude.
Quickly, please. Yes.
Your Excellencies, including their right to determine what happens to their land. And if I may be allowed some time to conclude my submissions on Restovia's obligation, our position is that because they overloaded the elders with technical information, failed to even allow more than 7 hours for a total of 200 Pillarman elders across 5 forums to actually meaningfully
Thank you,
provide
Counsel.
concerns.
Thank
Thank
you.
you, Your
Thank you.
Excellency.
Good afternoon. Please proceed.
Thank you. Mr. President Anaya, Honorable Judges Munoz and Akande, may it please the court. As introduced by my co-counsel, my name is Tan Kai Han, and I appear as second agent for the Dominion of Alakostra. For the next 22 minutes, I will be covering the issues of Ms. Liz Scott's extradition, as well as NEXCA's claim to state immunity. Now, I make 2 submissions. Firstly, that Alakostra did not violate its extradition treaty with Restovia when it refused to surrender Ms. Liz Scott. And secondly, that Restovia violated international law when it refused to grant state immunity to NEXCA in the civil suit filed by the estate of the late Mr. Domingo Montoya. I turn first to the issue of extradition. Under the extradition treaty, Alakostra is entitled to refuse to surrender Ms. Scott if her extradition would be contrary to the general principles of law under Article 38(1)(c) of this court statute. I make 2 points. Firstly, that ne bis in idem, or double jeopardy, is a general principle of law. And secondly, that Ms. Scott's extradition would place her in double jeopardy, contrary to the general principles of law. On the first point, Your Excellencies, a 2-limbed test is applied to determine the content and existence of general principles of law. The first is that a principle must be identified across national legal systems, a common principle. And the second is that this principle must be transposable to the international legal system. This test
would the double jeopardy principle also qualify as a norm of customary international law?
No, Your Excellency, our submission is only that it is a general principle of law and that that is what is required under the extradition treaty to bar Ms. Scott's extradition. And
So it does not constitute a...
no, Mr. President. Now, this test was articulated by the International Law Commission in its 2023 conclusions on the identifications of general principles of law, and it is reflective of this court's jurisprudence, for instance, in the 1949 Corfu Channel case and the 1970 Barcelona Traction case. Applying this test to the present circumstances, double jeopardy refers to the principle that no man should be tried twice for the same criminal matter following a final trial, producing a judicial decision on the merits. This principle, Your Excellencies, is found in most, if not all, national legal systems in the world, including common law traditions such as the UK, US, India, and South Africa, as well as civil law traditions such as Russia, Japan, and Germany.
So when you say no person should be tried twice in the same country, twice in different countries, twice in the same jurisdiction, or does it not matter?
We would say twice across different countries in this case is what we're arguing for, Your Excellency, a transnational rule of double jeopardy. But we note that what I've just cited are intrastate rules of double jeopardy. On top of that, however, we would point to the extradition acts of various countries, including Malaysia, the UK, Estonia, and Ghana, all of which contain double jeopardy as a mandatory grounds of refusing an extradition of a person. And so there is a common principle across these states.
So you have a few states that explicitly provide for a transnational rule against double jeopardy. Does that suffice to make it a general principle of law if it's just a few states?
Well, Your Excellency, it's not just these states that we rely on, but also extradition treaties concluded between many, many other states, all of which, to our knowledge, contain such an exception to double jeopardy.
But you said that for a general principle of law, you have to find a rule that's common to national legal systems. So how can we, what is the relevance of these extradition treaties for the purpose of finding a general principle of law?
Well, the relevance of these extradition treaties becomes more apparent at the second stage of finding a general principle of law, namely the stage of transposability. That's because the stage of transposability requires that a principle that is common to various national legal systems can apply on the international plane without conflicting with the existing structures and principles of the international legal system.
But can't the general principle also be generated, a general principle of law? Can't it also be generated by the international legal system and not just domestic legal systems?
Certainly,
And so in
Mr.
that
President.
sense, these treaties would be relevant to the formation of a general principle of international law in this regard? Is that part of your argument as well?
Yes, Mr. President, our alternative argument would be that double jeopardy can be found as an intrinsic general principle, but our primary argument is that these treaties are proof of transposability of a principle that is generated in national legal systems.
But on your first argument, sure, you argue that these treaties can be used for transposability, but first of all, you have to get over the hurdle, as you said, that it's a principle that's common to various national legal systems. So that's the key question, isn't it? Is the transnational principle of double jeopardy, or against double jeopardy, is that common to various national legal systems?
I understand that that was Your Excellency's earlier concern as well regarding commonality specifically. Now, while a rule of transnational double jeopardy is certainly not as common as an intrastate rule of double jeopardy, we submit that the exact same principle underlies all these different variations of double jeopardy, namely that no man should be tried twice for the same. And in any case, Your Excellency, the very foundation of a general principle is the concept of a principle that is borrowed from national legal systems. So it is fine if the principle that is common applies intrastate, because at the transposability stage is when we determine that this principle can also apply on an international level.
Counsel, but what about the international law in this argument that you are trying to expose? Because I miss references to the international law applicable. If so, could you please explain about it?
Would Your Excellency be asking about how this general principle manifests as a role of international law?
Yes, please.
It will only apply if I can establish the second stage of transposability, Your Excellency, and I will proceed to do so. Now, we note that where a principle already exists on the international plane, for instance, as is reflected in treaty rules, this would be evidence that it is transposable, as was noted by the International Law Commission in its 2025 Fourth Report on General Principles of Law. Now, we say that double jeopardy is transposable to the international legal system, and we do note that the respondents have argued in their written memorials that double jeopardy conflicts with the principle of sovereign equality, but we would respectfully disagree with that. Per the 1970 Friendly Relations Declaration, sovereign equality merely requires that the same legal rules must apply to all states equally. Now, we acknowledge, Your Excellencies, that an application of a transnational rule of double jeopardy would require states to refrain from exercising their own criminal jurisdiction when another state has already subjected an accused to a final judicial decision on the merits. However, Your Excellencies, this rule applies equally to all states.
So how about to indigenous peoples? Does it apply to them? Say, to the Pilimon, I assume they have their own jurisdiction, internal dispute resolution mechanism. What if Ms. Scott had been adjudicated by that and held not guilty or guilty? Does this rule apply to them as well? To
Now,
their judicial systems?
Mr. President, we do not go so far as to suggest that the Pilimons are a nation of their own. Their right to self-determination is an internal
but
right.
I assume they have, like many indigenous peoples across the world, have their own jurisdiction, their own internal judicial or adjudicative dispute resolution system.
They are certainly entitled to apply their own dispute resolution systems as long as it is with respect to the territorial sovereignty of the states in which they are contained.
So say they prosecuted Ms. Scott and found that she was not guilty or guilty, either one. Would that be subject to the double jeopardy?
No, Mr. President, we would not say that because the Pilimons cannot be said to be recognized as a sovereign state. And when we talk about transnational double jeopardy, we are talking about the principle as applied between recognized sovereign states. Now, on my earlier point regarding why it does not conflict with sovereign equality, we do note that any principle of double jeopardy would apply across all states equally. So even if it were to produce a differentiated result in this case, that does not mean that the rule contradicts with sovereign equality. If, for instance, Vestovia had prosecuted Ms. Liz Scott first, we certainly would not be trying to prosecute her again, which takes me to the facts of this very case, Your Excellencies. Ms. Scott is being tried for the exact same conduct for which the Alacostrian Court of Appeal has already tried her. This can be seen at paragraphs 40 and 44 of the complaint.
The same conduct or the same crime?
The same conduct is our primary submission, Your Excellency, and the reason why the same conduct test should apply on an international level is because there is a lack of harmonization between national criminal legislation, as was noted, for instance, by the European Court of Justice in the 2006 case of Van Esparek. But even if we were to compare the crimes in Alacostra and Restovia, we submit that they are the substantially similar offenses that would place Ms. Scott in double jeopardy. We take guidance, for instance, from the test applied by the UK House of Lords in the 1964 case of Connolly and DPP, in which it states, where facts fulfill the legal elements of one offense, fulfill the legal elements of the other, that can be considered the same offense, and that is the case in this situation. Now, the second inquiry for the court would therefore be whether Alacostrian Court of Appeal's decision was one that was on the merits. And we say that it was, Your Excellencies, notwithstanding that she was acquitted for a breach of her right to silence. The reason for this is because fair trial rights are a matter of substance and not mere procedural technicality. This was noted, for instance, by the European Court of Human Rights in the 2023 case of Lalique and Poland. Now, this is because a breach of fair trial rights affects how the court assesses the evidence against the accused. For instance, it changes what kind of inferences can be made from the evidence that Ms. Scott has
But
given.
in this case, the court didn't get to that evidence, did it?
Well, it did, Mr. President, and we can say that because, as can be seen from paragraph 43 of the facts, the court did go through a full briefing of the information that was provided before the first court, as well as the arguments between the parties. And so the court did have sight of all the evidence before them, and a breach of a right to silence would affect the way they considered the evidence. For instance, in the kind of inferences that can be drawn from evidence that was obtained in breach of a right to silence, and the consequences and the inferences and the conclusions that the court can reach based on such evidence, all of which, Your Excellencies, goes to the decision on the merits because it goes to a consideration of Ms. Liz Scott's criminal responsibility for fulfilling the elements of the charge. And therefore we say Ms. Scott was subject to a final judicial decision on the merits in Alacostria, and her extradition would place her in double jeopardy, contrary to the general principles of law. I turn now to my second submission on state immunity, Your Excellencies. Now, under Alacostria's fourth prayer, we submit that Restovia violated international law by refusing to grant the National Extraction Company of Alacostria, or NEXCA, state immunity in the civil suit filed by the estate of the late Mr. Domingo Montoya. We make 2 points. Firstly, that NEXCA was entitled to state immunity for its operation of the SARV on the Gordian Gorge. And secondly, that the personal...
Did you refer already the transposability question in the double jeopardy principle, in the non-bis in idem principle? I missed the point about the sources and international law that you use. Could you please summarize that?
Yes, my summary of the ne bis in idem principle is that it is a general principle of law under Article 38(1)(c) of this court statute, and that is because upon applying the test of commonality and transposability, we can identify such a principle, which is then incorporated into Article 4 of Alacostria's and Restovia's extradition treaty as a preclusion to extradition. Now, on the issue of state immunity, our second point would be that the personal injury or loss exception, also known as the territorial tort exception, does not apply in this case. On my first point, acts that are an exercise of sovereign authority are cloaked with state immunity from the jurisdiction of foreign national courts. This is a well-recognized rule of customary international law, recognized by this court, for instance, in the 2012 case of jurisdictional immunities. Immunity, we submit, extends to a separate entity that is authorized by a state to perform and is actually performing an act in the exercise of sovereign authority. And that is because these acts are attributable to the state. In this case, NEXCA was indeed authorized under national law, as can be seen at paragraph 24 of the compromise and 26. It was authorized by Parliament and also the Minister of Foreign Affairs to bid in the Gordian Gorge project. The real question for this court, then, is whether or not the operation of the SARV to obtain cost estimates in furtherance of the Gordian Gorge bid was indeed an act in the exercise of sovereign authority.
Before we get to the acts in the exercise of sovereign authority point, are you suggesting that merely because the state authorized the conduct is attributable to the state? Is that the claim?
Yes, authorization under international law would mean that the act is attributable to the state, but it does not instantly accord immunity for the act, Your Excellency.
But your claim is that if it's attributable and it's something done in the exercise of sovereign authority, then there's immunity. On the attribution point,
yes,
where can we find this principle that just because an act is authorized by the state, it's attributable to the state? Where do we find that?
Now, one example of where you could find it would be the UN Convention on the Jurisdictional Immunities of States and Their Properties, which we note is not enforced yet, but we say it is reflective of the possibility that separate entities can obtain immunity where they are authorized by a state to act. Now, this rule of attribution can also be found at Article 5 on the draft articles on the responsibilities of states for internationally wrongful acts. So these two sources and state practice across various states, in particular in their state immunity acts, does show that these acts attributable to separate entities.
So just so I'm clear, any act that's attributable to the state under the standard you just laid out is then shrouded by immunity?
Not at all, Mr.
No.
President,
Okay,
not
so
at all.
there's a distinction between the two.
Yes, attributability comes before ascertaining whether
Okay.
the act is cloaked with immunity.
But it's not sufficient to establish immunity.
Absolutely not, Mr.
Okay,
President.
So what are the key elements to
Well,
establish immunity?
the key element is that the act must be an exercise of sovereign authority, and how we figure out whether that act is such an exercise is by looking at both the nature and the purpose of the act. Now, this nature and purpose test is well established by state practice across many states, including Philippines, Italy, the UK, Malaysia, etc. And so it is this test that we rely on to establish that NEXCA's operation of the SARV was an exercise of sovereign authority. We
So
note
you say nature and purpose.
nature and purpose, yes, Your Excellency.
Can you give us an example of where we would find this nature and purpose test?
Certainly, Your Excellency. Now, one example I can give you is the 1994 case of the Holy See and Heriberto Rosario Jr., decided before the Supreme Court of the Philippines. In this case, the sale of land was in question, but it was not considered as a commercial act just because of its nature. The Supreme Court looked at the purpose of the act. The sale of land was for the purposes of building the official residence of the ambassador of the Holy See to the Philippines, and for this reason, it was considered to be a sovereign act. Now, this same trend is found across many states, for instance, in the 2005 Italian Court of Cassation case of Borri, Argentina. The purpose test is also found in the UN Convention that I earlier cited, and it is established by state practice.
Isn't it the case that everything the state does is for the purposes of the state? So if you're using the purpose, wouldn't all acts then attract immunity?
Well, we would disagree with that, Your Excellency, and that's because the state can act for a purely commercial purpose as well, a profit-making purpose. And in fact, that was the case in the 2017 case of Beijing Urban Construction Group and Yemen, heard before the ICSID. In that case, the building of an airport was for a purely profit-making purpose and was not a sovereign act. Now, in this case, however, at paragraph 26 of the compromise, it is clear why Alacostia submitted the bid for the gorge. Firstly, due to a lack of rare earth minerals within its own territory, and secondly, due to the importance of these rare earth minerals for the existing and emerging industries in Alacostia. On top of that, the bid in the gorge was authorized as consistent with Alacostria's national security and foreign policy. And for all these reasons, we say it was done with a public purpose. But we don't just rely on purpose, Your Excellencies. We also rely on the nature of the act. Also found at paragraph 26 of the compromise is the fact that Parliament required NEXCA to ensure that all activities were consistent with its obligations under the Alacostria-Restovia Plateau Agreement.
Sorry, Agent, at some extent do you take into account the evolving standards, inter-American, international, in relation to business and human rights, considering the obligations, evolving obligation the states has to control business, especially when business is a national business? Could you please tell me something about that?
Of course, Your Excellency. Now, there is a difference between a company that is required to act in accordance with internal law, domestic law, imposed by the state which it belongs to, and a company which is itself subject to the international obligations that its home state has undertaken. In this case, NEXCA falls within the latter category, as was also recognized by the Restovian Court itself at paragraph 52 of the compromise, in which it acknowledged that NEXCA was, and I quote, required to uphold Alacostria's international obligations. For these reasons, we say that the Gordian Gorge bid and the operation of the SARV was immune, which takes me to my final point on the territorial tort exception. Our primary submission in relation to that is that the territorial tort exception is not custom, as there was no widespread state practice. But even if it was, taking the elements of the territorial tort exception as set forth by the respondent in their memorials, the requirements are not fulfilled here, because although the harm to Mr. Montoya happened within Restovian territory, the negligence of NEXCA happened solely within Alacostrian territory, as can be seen at paragraph 38 of the compromise, which is why the territorial tort exception would not apply in this case. For these reasons, we humbly pray that Alacostria's prayers be granted. Thank you.
Thank you very much. Respondent? Agents for Respondent? Please continue, or please start whenever you're ready.
Mr. President, Your Excellencies, good day, and may it please the Court. It is an honor to be before you today. I am Jose Andres Gonzalez, and together with my co-agent, Mr. Juan Gismo Lema, and our of-counsel, Ms. Jasmine Pandy, we respectfully enter our appearance as agents for the respondent, the Republic of Restovia. As first agent, I will speak for 21 minutes on the first two prayers, while my co-agent will speak for 22 minutes on the final two prayers, and we respectfully reserve 2 minutes for rebuttal if necessary. Thank you, and may it please the Court. Now, Your Excellencies, for respondent submissions, we will address the first two prayers raised by the applicant. And in this manner, we will first discuss why Solana's request to intervene under this court statute should respectfully be denied. And then second, we will proceed to discuss why respondent did not violate any treaty or customary rule on obtaining free, prior, and informed consent. Now, if it pleases this court, I will begin with Solana's request to intervene. Now, earlier, the agent for the applicant had correctly outlined the requisites under Article 62 of this court statute, that first, there be an interest of a legal nature, and that it may be affected by the decision of this court. Additionally, they mentioned the proper object of an intervention, which was held in this court's most recent decision in Guatemala's intervention. Now, Your Excellencies, while we don't contest these standards, what respondent does contest is the way the applicant has applied it with respect to Solana's interests, because they mention two key interests here. First would be in the customary law of the Pilman people, as well as the parallel treaty of the Solana-Restovia Plateau Agreement as it regards to the Alacosia-Restovia Plateau Agreement, which is in dispute before this honorable court today. And I shall address both in turn. First, with respect to Solana's claim as raised by the applicant, that the customary law of the Pilman people, especially those in Solana, will be affected by the decision of this court between the two parties because they have an interest in the formation of customary law, specifically that of obtaining free, prior, and informed consent, has already been rejected by this honorable court in its 1981 decision of Italy's intervention between Tunisia versus Libya. In that case, Your Excellencies, we also dealt with the formation of a customary rule. The customary rule there was the maritime rights granted by the continental shelves of peninsular states. And while Italy wanted to intervene to understand how the formation of that customary rule would affect its interests, this honorable court held that participating through intervention, simply to understand how general rules are formed.
But counsel, at stake here is not just Solana's interest in how a customary rule is interpreted, is it? I mean, their interest has to do with the people of Solana, who are the Pilimons, right? And at stake in this very case is whether or not they were adequately consulted. They are the same, are the people, I guess that's one question that I would have for you. Are the people in Salonia the same people as the Pilimon in your country and in the applicants?
Mr. President, we recognize that point. And to address your question, we recognize that the Pilman people Pilman people in Solana do share cultural heritage with all the other Pilman states, like the applicant and the respondent, but they are different people considering they are different nationals protected by different state interests, which Solana is questioning
But
here.
aren't they part of the same indigenous people?
Yes, Mr. President.
Or are they three different indigenous peoples that happen to go by the same name?
No, Mr. President, we do agree that they are a transboundary indigenous people and part of the Pilman heritage. But if we take a step back and remember the requisites under Article 62, we are dealing with state interests and the ability of that state to protect those interests. So while we recognize that Solana may have an interest in the formation of a customary rule, we must remember that in this case, we are dealing with the general obligation to obtain free, prior, and informed consent as it affects all indigenous communities around the world.
Is that the claim of the other side, that it's about, that the interest of Solana is about the formation of general customary international law, or is the argument that the application in this case of customary international law will affect the rights of indigenous peoples that are nationals of Solana?
Your Excellencies, we recognize that the agent for the applicant raised an argument as regards to the latter, that the formation of this general rule will have specific implications to the Pilman indigenous people, especially those of Solana. But Your Excellencies, again, we go back to the standards of Article 62. And if we look at the cases, such as the Gulf of Fonseca case decided in 1991, the interest of a legal nature, which is simply defined by this court as a real and concrete claim based in law, must be connected to the dispute. And while we recognize that Solana may have their own customary governing principles pursuant to Pilman's spiritual tradition, what the interest in terms of an international rule is actually linking them to the dispute is that of a general obligation to obtain free, prior, and informed consent. So whatever decision this court will have on the obligations of respondent to obtain that consent, it may still not have an effect on Solana's state, considering that their Pilman people may govern themselves differently as regards to the applicant's nationals who have duly authorized Pilman representatives within their governance structures. So, Your Excellencies, at least on a customary layer, we are still dealing with that general principle which was already rejected by this honorable court. And if it pleases this court, I move to the applicant's second submission.
Just before you move on, you say it may not affect the interests of the people in Solana, but it may affect their interest, may it not?
Your Excellencies, to clarify the position, it will not affect Solana's interests in this case, because whether or not this court will rule on the specific standards that exist within the obligation to obtain free, prior, and informed consent, that will not change any of the governing structures of Pilman customary law, especially with respect to Solana's state. Now, if it pleases this court, I will move to address the prayer or the second submission of the applicant regarding the Solana-Restovia Plateau Agreement, and considering that it has identical treaty provisions in terms of Article 18 of the ARPA, that this court's interpretation of that obligation on respondent will probably affect the identical treaty wording. But as this honorable panel already correctly pointed out earlier, the rules of the 1969 Vienna Convention on the Law of Treaties already tell us that we do not simply interpret treaty provisions simply by their text, but also by their context, object, and purpose, as well as subsequent practice of the states. And if we see in paragraph 17 of the compromise, when the respondent was concluding in the 1971 negotiations, they were cautious to cede their sovereignty over to the Pilman people. So instead, they offered a purely consultation-based framework as a compromise. And the applicant state was fully satisfied with this outcome, which led to the ARPA, while Solana wanted further negotiations, which led to the SRPA. And we also see this in subsequent practice, considering Solana has always objected this project in principle, while the applicant state and its nationals have participated and even entered a bid in our indigenous consultation mechanism. Therefore, Your Excellencies, we clearly see that these two treaties are separate. And because we see that these treaties are separate, we go back to the 2001 decision of this court in the Philippines' intervention in the case concerning Pulau Ligitan and Pulau Sipadan Islands, where in that case, the Philippines also relied on a parallel treaty, the Sulu Overback Grant, in its claim of sovereignty in North Borneo. And in that case, Your Excellencies, the court recognized, while there are similar circumstances, to participate or intervene in a case merely out of concern that this court will have an interpretation on an international rule is improper for intervention. And to address the final point,
Could you better explain why this is not proper participation and why you challenge the ability of this court to listen Solonia and how this impossibility for this court could be against the interests of PLNM people, but also of the interests of the justice for this court.
certainly, Your Excellencies, a clear standard for an improper intervention or an improper intervener would be again in the case of Philippines, Pulau Ligitan, Pulau Sipadan, when the Philippines was rejected on terms of their intervention based on the Sulu over back grant. This honorable court held that it was simply not a real and concrete interest in the current dispute, because to assume that this court would apply the same treaty interpretation would simply be too speculative and thus not concrete. And an additional point by this honorable court was it cautioned against granting the Philippines' intervention, because since it was not a related subject matter, it would risk introducing a new dispute to the current dispute before this court. And this is exactly the prejudice that the respondent cautions this honorable court against. While we do not
Does it matter, counsel, that under Article 63, I know this is 62, under Article 63, if it had been a common multilateral treaty, any party to the treaty can intervene. In this case, it's not one multilateral treaty, but it's two separate bilateral treaties, but with common origins, common texts. So if it would be improper, as you suggest, under Article 62, why would there be that provision in Article 63? Or if I could put it the other way around, if it's deemed to be proper under Article 63 to have that kind of intervention, why would it be improper under Article 62 to be able to intervene in the case of two separate but linked bilateral treaties?
Your Excellencies, it would be perhaps proper under Article 63 if we did have a multilateral treaty. You are correct to point out that Article 63 is also noted by this court as mandatory intervention, whereas state parties can intervene as a matter of right when it pertains to the interpretation of a multilateral treaty, because again, it is their right as states parties. But as you correctly pointed out, Your Excellencies, we have two separate bilateral treaties here. And while we recognize the identical treaty provisions, Respondent remains firm in its contention that they do not confer the same obligations because they were concluded under different circumstances with different state parties, and in terms of subsequent practice of how those state parties acted, they had different intentions. So it would not be...
But isn't the purpose of the treaty, both treaties essentially the same, and the subject matter of both treaties essentially the same?
And if I can add the text also?
Your Excellencies, in terms of the text, they are the same, at least with respect to Article 17 and 18. And Mr. President Anaya, we do recognize that, in a sense, the object of that treaty was to protect the Gordian Gorge and its access. But in terms of the standards raised by the applicant and Solana, they were different. So they may have different implications of how they want those consultation procedures contemplated under those treaties in a different way. And it makes sense here, Your Excellencies, because Applicant is a developed state and wanted to further emerging industries by entering a bid through NEXCA, while Solana objected the project in principle. Therefore, there are clearly two different intervening interests with respect to the SRPA. And Your Excellencies, and if we look at the most recent decision of the Guatemala intervention, we remember that in Judge Charles Worth's opinion, that Article 59 does not, while he recognized that Article 59 does not necessarily insulate or limit the decision of this court in every single case, it still can afford that protection when we are dealing with two separate bilateral treaties, where this court can limit its interpretation of one treaty and not apply it to the other.
So if this court were to say in this case that the text of one of these treaties means something, the text in its ordinary meaning means something, would that not have some effect on the interpretation of the other treaty?
It may have some effect, Your Excellencies, but again, it wouldn't be proper, because if we were to use that logic, perhaps the logic used in paragraph 66 of the Diallo decision, where they held that similarly concluded treaties that have similar provisions, such as the ICCPR and the African Charter on Human Rights, could be interpreted consistently, it would not be proper when they do not have the same context or the same standards that they were concluded under. But Your Excellencies, even assuming this court finds that it is an interest of a legal nature, it simply would not be affected by the decision of this court because this court can limit its interpretation under Article 59. Now, if it pleases this court, and if there are no further questions,
Just one more question.
Certainly, Your Excellency.
Just on Article 59.
No worries, Your
Just on
Excellency.
Article 59. But if your argument was correct on Article 59, would there be any case where the court would permit intervention?
Certainly, Your Excellencies, and if I may point this honorable court to the most recent decision decided a few weeks ago. In the Guatemala's intervention, the court discussed the probability of just using Article 59 to protect the interests of Guatemala from the current case between Belize and Honduras. But the court found there that Article 59 would still not be able to protect Guatemala because in that case, it was a case of sovereign ownership. And there, sovereign ownership, even if limited to the decision between the parties, already excludes other claims of ownership. So it would practically defeat the case of Guatemala. But that's not the same interest here, Your Excellencies. Because we have two separate treaties that are governed by two separate state parties, this court can still use Article 59. At the end of the day, Your Excellencies, Solana's rights will be what it was at the outset, untouched in rights, unchanged in law, fully preserved. Now, if we move to the second prayer raised by the applicant, on respondents' obligations to obtain free, prior, and informed consent. They mentioned that we have the duty to consult the duly authorized Pillman representatives with the aim of achieving consent, both under Article 18 of the ARPA, as well as in customary international law. Now, Mr. President and Your Excellencies, respondent does not contest the standards raised by the applicant because, Your Excellencies, respondent is also of the position that what we are dealing with here today is an obligation of conduct to consult in good faith. So, in terms of establishing respondent's faithful compliance with its treaty and customary law obligations, allow me to walk this court through the pertinent facts of this case. Now, Your Excellency.
So you agree with the applicants that there is a standard of customary international law requiring free, prior, informed consent?
Mr. President, we agree only to the extent that the standard raised by the applicant is free, prior, and informed consent as an obligation of conduct with the aim of achieving consent, but not granting consent as a veto power over to indigenous communities. Therefore, Your Excellencies, respondent is prepared.
So you disagree with them? Because
Apologies, Mr. President.
you disagree with them because they say that there should be consent achieved.
Okay, apologies, Mr. President. Then we do qualify that the object of the consultations in good faith should be.
All right.
Yes, Mr. President.
Thank you.
And this is consistent, actually, with customary international law, because if we look at the 90 specially affected states that host indigenous communities, their domestic legislations of over 70 states only reflect a good faith obligation of conduct. And in terms of opinio juris, we do recognize the point raised by the applicant that over 193 states have voted in favor of the UN Declaration of the Rights of Indigenous Peoples. Many states, like New Zealand or Canada, for example, have expressly adopted the UN Declaration of the Rights of Indigenous People, but still do not reflect a consent veto over to the indigenous people. If we look at Canada, Your Excellencies, they even have an express adoption through the UNDA. That is the state's express adoption of the UN Declaration of the Rights of Indigenous People. But they have decided very recent jurisprudence in 2025, such as the Kebawik First Nation case versus Nuclear Laboratories, as well as the Lumi Nation case versus the Supreme Court of Canada. Both cases ended with the decision that consent is not a veto power, but only an interpretative lens in informing how we do our consultation obligations. Now, this honorable court may be asking themselves, what are the standards of good faith consultations? And as pointed out in paragraph 167 of the most recent jurisprudence in Canada, the Lumi Nation case, we see this principle is simply to put the indigenous communities in a place where they can influence the outcome. And more specifically, we see this in 3 badges. First would be notification. Second would be information sharing through public fora, for example. And third would be the acceptance of those.
But doesn't it matter what's being consulted? I mean, isn't that relevant here? I mean, whose land is this?
Mr. President.
Is this Pilimon land where the mining was to happen?
Mr. President, respondent is of the position that it is within its territory and pursuant to the principle of permanent sovereignty over natural
yes, but who's the owner of the land?
Mr. President, Respondent submits that it is still the respondent state, Restovia, but it does recognize the cultural ties of the Pilman people, which is why it enacted the indigenous consultation mechanism to preserve the self-determination rights of those.
Your position is that it is not owned by the Pilman, the land itself, or the resources?
Yes, Mr. President. Respondent is of the position that it owns its land, but it does recognize its international obligations to put the indigenous Pilman peoples at the forefront of those decisions. And Respondent, sorry,
How
Excellency.
do you define meaningful or effective participation regarding international law and regarding the case?
Your Excellencies, meaningful participation is most clearly defined in paragraph 167 of the Lumi Nation case versus Canada, where they are able to influence the outcome of the decisions of the state. And Respondent submits through the various facts that we have in this case, we were able to do that. As early as paragraph 20 of the compromise, even when we opened the bidding process, we ensured that any qualified bidder would make sure to follow the strict provisions of the ARPA and the SRPA. When we had the public forums, we ensured that there were technical special advisors as well as experts on Pilman dialect to translate that information. And we see the success of this endeavor, Your Excellencies, seen in majority participation of over 200 elders, 120 of whom even gave their support to the project. And most importantly, Your Excellencies, we see this good faith in paragraph 31, where all of the recommendations of the Pilman elders, specifically avoiding the use of explosives and road constructions on the gorge, were incorporated, and we demanded that all finalist bidders incorporate those safeguards, just that anyone we choose would already reflect the interests of the Pilmans.
But what about the low participation of Pilman people and the kind of methods that you use to provoke the participation, given the situation of Pilman people without access to internet and electricity, etc.?
Your Excellencies, we ensured their accessibility and participation by hosting multiple forums, over 15, both public and online and on-site, so that those without internet access could travel, even because it was over the span of several months. And we see that it was clearly successful because they were informed. I note my time. May I simply address the question?
You can conclude quickly.
Thank you. We see the success of that participation because they were even able to influence how the project would go forward with limitations such as the use of explosives and road access impediments. So thank you, Your Excellencies, and may it please this court.
Thank you. Thank you, Counsel. We'll now hear from your colleague, the second agent for Restovia.
Mr. President, Your Excellencies, good day, and may it please the court. My name is Juan Gismolema, respectfully appearing as second agent for the respondent. Over the course of the next 22 minutes, Your Excellencies, I will be arguing respondent's final two prayers in the way that the applicant has raised them. First, that Alicostria violated its obligations under the extradition treaty when it refused to surrender Ms. Scott, and second, that Restovia lawfully refused to grant state immunity to Nexca. Thank you, and may it please the court. Continuing then with our third prayer, Your Excellencies, applicant earlier submitted that nebis in idem is a general principle of law that would be violated by Ms. Scott's extradition and trial in Restovia. Allow me to show this bench why this is not the case. Now, as regards nebis in idem status as a general principle of law, we agree with the applicant's standards that the elements of a general principle of law are those of commonality and transposition. However, we submit that they have been misapplied in this case. As to the element of commonality, the applicant cited various legal systems and countries pointing to the principle existing in those jurisdictions, and this we do not contest. However, we simply point this court to the report, rather the second report, of Special Rapporteur Marcelo Vasquez Bermudez on general principles of law, where he stated that where a rule fundamentally differs across legal systems, then no general principle can arise. And we submit here that the fundamental difference is seen in the irreconcilability as to the constitutive elements of nebis in idem across jurisdictions, which are the finality of the prior decision and the identity of the subject matter. As regards the identity, we see in jurisdictions within the EU, South America, and African Union that a person cannot be prosecuted twice for the same act. But in jurisdictions like the US, Philippines, and India, a person can be prosecuted twice for the same act if they fall under different offenses. And thus, to illustrate this irreconcilability, a person in the US can be tried twice for the same act of selling drugs. But if this very same person were in the Netherlands instead, then a second prosecution would actually be prohibited, thus pointing to this lack of harmony across jurisdictions when it comes to nebis in idem. And we see the same lack of harmony in the finality element, wherein common law jurisdictions treat trial court acquittals as final. But in civil law jurisdictions, this can actually be appealed all the way to the highest court. So again, to illustrate, Your Excellencies, a person in the US is already protected by nebis in idem after acquittal by a trial court. But if the same person were in the EU, then they would not actually be protected by this principle yet.
You point to some differences as between different countries, but isn't it always the case that with general principles of law, what you're looking for is commonalities with regard to the essence of the principle? There will always be differences in domestic law, but that doesn't prevent one being able to find that there's a general principle of law.
Yes, Your Excellencies, and we recognize this. However, when it comes to the principle of nebis in idem, the applicant actually earlier correctly stated its essence, which is that a person should not be prosecuted twice for the same matter. And this exactly is the principle, Your Excellencies, that we come before this court for to say that it is not common. Because this essence shows us, rather, that when we talk about the same criminal matter, the question will always be what constitutes the same matter. Is it the conduct or is it the crime? And to borrow the words of Judge McNair in his separate opinion in the Southwest Africa case, the way that international law borrows from these municipal concepts is not by simply importing them lock, stock, and barrel, ready-made and fully equipped with a set of rules, which is why we must account for these differences, especially when it comes to nebis in idem, whose entire essence is hinged on what constitutes this very matter.
But wasn't Judge McNair essentially saying we shouldn't actually be looking at all the details? We should be taking the essence of it. So isn't that the point, that can we not take the essence of a principle that we find in every domestic legal system and then apply that in international law?
Your Excellencies, yes, Judge McNair was referring to that as regards the mandatory system under the PCIJ. But what we come before this court to say is that the essence of nebis in idem itself is tied to what constitutes this very matter, which is why we submit that it cannot be considered common, because this is exactly the principle that nebis in idem protects. Now, to quickly address the applicant's earlier point that nebis in idem is considered intrinsic to the international system, we submit, Your Excellencies, that it is not, since as found by the ILC in its analytical work.
But isn't that requirement of it being intrinsic, according to the Special Rapporteur's report that you just referred to, I could be mistaken, but I believe that that requirement is linked to norms, general principles that are generated not by domestic legal systems, by the international legal system itself.
Yes, Mr. President, and in doing so, the applicant earlier stated that even a transnational nebis in idem is common, and they claim that this transnational nebis in idem is intrinsic, to which we say, Your Excellencies, that it is not, since the ILC defined intrinsic as a principle specific to the international legal system and reflective of its basic features. Yet we submit, Your Excellencies, that rather than being intrinsic, nebis in idem does not actually, or rather is not, yes, Mr. President? there any?
Go ahead. I'm
Apologies,
thinking.
Apologies, Your Excellencies.
I'm thinking.
We submit, Your Excellencies, that
You can
never-
ask me questions though, if you really want.
Maybe later on, Mr. President. Now, when it comes to transnational nebis in idem, we submit that rather than being formed within the international legal system, it has purely domestic roots. And as to being reflective of its basic features, we submit that it is actually...
You say it has purely domestic roots, but they say we see this reflected in a range of extradition treaties. So that's not domestic, that is international, isn't it?
Yes, Your Excellencies. And to this, we cite the third report of Special Rapporteur Vasquez Bermudez, and us assuming, without conceding, that transnational nebis in idem is a principle formed in the international system. The Special Rapporteur stated that states must recognize the principle as generally applicable outside of any particular treaty regime or customary rule. And yes, the applicant cited various extradition treaties, which actually militates against their claim, as all this shows is that states do not recognize nebis in idem in a transnational sense.
But in the work of the ILC, it does accept that general principles of international law formed within the international legal system can be found in treaties. So the fact that you see it in treaties doesn't necessarily mean that it is therefore not a general principle of law. In fact, the ILC seems to say the opposite with regard to that type of general principle.
Precisely, Your Excellency, and to this we make 2 points. Firstly, we completely agree that presence in treaties can actually serve as evidence of being transposed to the international system. However, in citing the third report of the Special Rapporteur, we state that, according to Mr. Vasquez Bermudez, states must recognize it as being generally applicable even outside of a particular treaty regime. Yet here, Your Excellencies, we see that states do not recognize a transnational nebis in idem outside of treaty, since it explicitly requires consent, which is attained through the treaty negotiations entered into between the parties. But secondly, Your Excellencies, as to the point about presence in treaties proving transposability, we move on to this element of transposition. And Your Excellencies, to this we state that although the applicant earlier cited that this presence in multiple instruments is evidence of treaty, or rather is evidence of nebis in idem being transposed, we submit that this is merely evidence of it that doesn't necessarily conclude that it is actually transposed, since the ILC itself found that for a principle to be transposed to the international system, it must be compatible with the fundamental principles of international law. And we note the applicant earlier attempted to preempt our position that it would be violative of sovereign equality. Yet in doing so, they failed to overcome or explain why it would actually violate this principle, seeing that the Friendly Relations Declaration entails that states enjoy the rights inherent in full sovereignty, one of such rights being the right to uphold criminal jurisdiction. Yet, if we were to accept the applicant's position, this transnational nebis in idem would effectively extinguish our criminal jurisdiction and force us to accept the decision of another state made under their own laws.
Is this going to be the case for any rule of international law? Any rule of international law that imposes obligations on states will limit the rights of the state in the absence of the rule. So you're saying if we accept this rule, it will limit our rights. Therefore, we can't accept this rule. But that's the case for all rules of international law.
To clarify, Your Excellencies, what we point out in particular here is that as nebis in idem is a limitation on sovereignty, we cite the case concerning the SS Lotus, where this court's predecessor explained that limitations on sovereignty are not to be presumed. And therefore, Your Excellencies, absent a clear and express consent on the part of our state, we submit that a transnational application, specifically of nebis in idem, cannot be assumed to apply between our states, Your
But my
Excellencies.
point is this would be the case for every general principle of law. By definition, a general principle of law, there isn't this specific type of consent. So would one still be able to find a general principle of law if it's sufficient to say it will restrict our sovereignty?
Yes, Your Excellencies. Or rather, to clarify, did you refer to principles that would limit on sovereignty being arisen to a level of a general principle? To this, Your Excellencies, we say that no. However, there are other general principles that can still apply in this case. For instance, we see the principles of in dubio pro reo or the presumption of innocence, which do not necessarily result in a limitation of our sovereignty, and of course, these can apply here.
Could you add, please, Counsel, some argument or source related to international criminal law that is applicable to this matter?
Your Excellencies, apart from those already mentioned,
Yes.
here, Your Excellencies, considering that what we have is this extradition treaty, the typical requirement is that of double criminality. And this brings us to our third submission, Your Excellencies, that even if this court were to find nebis in idem as a general principle of law, then it would not be, it would still not apply in this case, considering that its elements are not met. The double criminality element leads me to the offense involved here. We note, the applicant earlier cited that the same conduct approach should be what is employed by this court in determining a transnational nebis in idem. On the contrary, however, we submit that the same offense approach is much more prevalent in international law as it is present not only in the ICCPR, but even in the UN Model Treaty on Extradition. And so we look to the actual offenses involved here, which clearly involve different elements. One requires a foreign nationality and an economic advantage, while the other does not. And clearly these are different elements that are not sufficiently subsumed. Now, as to the more important point here, Your Excellencies, that we wish to bring up, there was no final determination on the merits to warrant a refusal of Ms. Scott's extradition. Your Excellencies, in the 2024 case ruled by the European Court of Justice in Parquetul de Pelanga, they found that a final determination on the merits is present when there is a competent authority assessing such evidence, and decision is rendered on the basis of that evidence. Yet here we clearly see in paragraph 43 that the decision of the Alicaustrian Court of Appeal was not rendered on the basis of the evidence pointing to her guilt or innocence, but on the mere procedural error of failing to read Ms. Scott her right to remain silent. But, Your Excellencies, we are not so unreasonable as to presume that Ms. Scott's human right is not important in this case, which is why all that we seek is that there be a final determination on the merits that will ensure that both interests of Ms. Scott and our state are met, seeing that if there is an actual determination as to her guilt or innocence, our state would be satisfied regardless of the result. That being said,
Will the failure to read her rights, be incorporated in the proceedings in your country?
Your Excellencies, yes. And these are two different proceedings, the one that was conducted in Alicostria and the one to be conducted in our state. And we will ensure, Your Excellencies, if this extradition were to be granted, that that failure would be rectified in the Restovia. Thus, nebis in idem not meeting the elements of commonality and transposition is simply not a general principle of law, and in any case, it would not be violated here. To move on then to our fourth and final prayer, Your Excellencies, we submit that Restovia did not violate international law when it refused to grant state immunity to Nexca. Earlier, the applicant raised 3 points: that Nexca was entitled to perform sovereign acts, that they were actually performing sovereign acts, and that in any case, the territorial tort exception does not apply here. And I shall refute each of these points in turn. As to entitlement, we first point out that Nexca is a state-owned entity, which is defined by the UN Convention on State Immunities as an entity with independent legal personality, shown by its capacity to sue or be sued, and to acquire or dispose of property. All of these are met, since Nexca was sued in its own name and acquires its own property, such as the SARV. And since it is a state-owned entity, the ILC, in its commentary to the UN Convention, stated that state-owned entities are presumed not entitled to perform sovereign acts precisely because they are typically put up to perform commercial functions. Now, we note that this is a rebuttable presumption. However, we submit that even though there are various facts in the compromise pointing to the fact that Nexca might be entitled to perform such sovereign functions, like being created by an act of parliament or being 100% government-owned, we submit that international decisions have already shown that these are not conclusive. We see, for instance, in the case of Trentex versus Central Bank of Nigeria, wherein the central bank was also 100% government-owned and created by Nigerian statute. But the UK court found that since there was no showing that it was created or established precisely to perform sovereign functions, then it was not found entitled to perform sovereign acts. And we see the same thing here. Nexca, according to paragraph 24 of the compromise, was not necessarily established for sovereign functions, but to engage in mining operations both in Alicostria and abroad. And so there's no particular showing that it was actually established for sovereign purposes. but to the more important issue here, as to whether Nexca was actually in the performance of such sovereign acts, we still maintain our position that they were not. Now, Your Excellencies, this court found in the jurisdictional immunities case that pursuant to the restrictive doctrine on state immunity, states are only entitled to immunity for their acts jure imperi and not their acts jure gestionis, precisely because, as found by Lord Wilberforce in the Congreso del Partido case, today states enter into more commercial engagements and private dealings with private individuals.
What are the specific acts here that you're pointing to that aren't sovereign acts?
Your Excellencies, to clarify, how do the specific acts here point to commerciality? Is that Mr. President's
That you
concern?
say are not sovereign acts? And hence
Yes, Your
not sovereign
Excellency.
acts. Yeah.
We find that, as the applicant rightly stated earlier, the primary means for determining a character of an act is by looking at its nature. And we see here that this venture, by its very nature, is commercial in every sense of the word.
You're basically talking about the robot, right?
We're talking, Your Excellencies, about the mining activity in itself that was entered into by Nexca in our state.
And is it just the nature of the act, or is it also looking at the context, or as they put it, the purpose? So it's not just mining, it's mining of rare earth minerals, which they want for particular defense and security needs. Isn't that the context?
Your Excellencies, we submit that context can be taken into consideration. However, context and purpose does not override the nature, which, as found by the ILC, states actually preferred having the nature test as it served as a more objective standard in determining...
What is the nature test? What does nature refer to, in your view?
The nature refers to the entirety of this mining activity, Your Excellencies, which clearly points to a commercial transaction, especially when we take the context into consideration. Now, we cite the case of BUCG versus Yemen, wherein the ICSID stated that where a contractor enters into a competitive bidding process alongside other private companies and has their bid selected on commercial merits, then these can point to commerciality. And so we look at the context here. Paragraphs 35 and 48 of the compromise show that Nexca was involved in the site survey to confirm cost estimates.
So all of this is true, but couldn't one say that the context is the mining of rare earth, minerals, and that's a very particular type of thing which the state wanted for sovereign purposes?
Well, Your Excellencies, yes, we can say that the rare earth minerals were contemplated by Nexca here. However, we do not submit that it necessarily points to a sovereign purpose. The applicant earlier cited paragraph 26 of the compromise, which correctly stated that the Alacostrian Minister of Mining contemplated these minerals for existing and emerging industries without any particular showing to a particular sovereign purpose. And Your Excellencies, these rare earth minerals can in fact be used for such sovereign purposes, but at the same time, they can also be used for technology such as cell phone screens, which do not necessarily mean that in every instance, these minerals are used for sovereign or national security purposes. And absent any showing in the compromise that this is precisely what Nexca contemplated, we cannot assume that this was the actual purpose engaged into by Alacostria into entering this project. And thus we submit that taking all of the context into consideration, we can still see that involved here was a commercial venture, and therefore Nexca should not be entitled to immunity. However, on the final note, that the territorial tort exception also does not apply in this case, we submit that it actually does because it is established as customary international law.
Counsel, please. Thinking in the death of Domingo Montoya, I wanted to know if in some point Restoria is not also has some kind of responsibility of culpa in vigilando, because the facts happened in your state, in your territory. So do you have something to tell about this possibility?
Your Excellencies, we submit that it is actually our duty and our obligation to ensure that the Montoya estate would be entitled to access to justice. And as regards the actual event that occurred resulting in the death of Domingo Montoya, all these acts are clearly attributable to Nexca, as the applicants themselves have cited. But here, Your Excellencies, this is precisely why we invoke the territorial tort exception, as doing so would allow greater access to justice for the estate of Domingo Montoya, and as even found by the ILC, by having these proceedings in another state, it would result in a forum non-convenience.
What is the legal source that you invoke to to apply the tort exception?
The tort exception, Your Excellencies, we cite various state practice and opinion juris which establishes the territorial tort exception as custom. We cite state practice in countries like the US, UK, Australia, South Africa, Argentina, Singapore, Israel, and Australia. And
in the jurisdictional immunities case before this court, did this court accept the territorial tort exception?
Your Excellencies, no, but only in the context of armed conflicts or in the context of jus cogens violations. However, Your Excellencies, the court did not make any particular pronouncement as to the rather existence of the principle in general outside of that context. And we even cite the opinion of Judge Gadja in that case, wherein he stated that this territorial tort exception has existed since the 70s. And to date, Your Excellencies, no state has objected to it being a rule of customary international law.
Thank you.
Thank you.
Thank you, Counsel.
Thank you, Your Excellencies.
Rebuttal?
In relation to issue 2, the first agent for the respondent contended that Restovia, and I quote here, put the Pilaman people at the forefront. This was not true when elders from 2 states called for the tender process to be halted at 22. This was not true when the remaining participating elders opposed the project in principle at 33. And this was not true when it unilaterally awarded the contract to Hyperion at 49. We fundamentally disagree with any discussion of the obligation as a veto right, as it detracts from the conversation that should in fact be had. Indeed, this court should properly listen to the opposition of indigenous people and give recognition to the First Nations of the land. Thank you, Your Excellencies.
Thank you. Sir, rebuttal?
Mr. President, Your Excellencies, once again, good day. Respondent has just one point for rebuttal in response to the applicant. The applicant rebutted that the respondent failed to put the Pilman people at the forefront of this project. And to support the rebuttal, the applicant mentioned at the core of it was the awarding of the contract to Hyperion and also failing to consider the calls for the moratorium by the applicant and the Solanian state. But Your Excellencies, the applicant fails to regard the consistent standard that is provided for us by international law. As mentioned by Special Rapporteur James Anaya in page 9 of his report, states can continue to develop their project so long as they enact good faith measurements that allow indigenous communities to influence the outcome such that the state can proceed subject to those limitations. Across all 3 finalist bidders, even Hyperion, they were included in the bidding process. They were included in the information sharing.
Can I ask, what is the status of that special rapporteur's report that you referred to? Why should this court take that into account?
Your Excellencies, pursuant to Article 38, Paragraph 1D, on the works of the most highly qualified publicist, it is very highly...
I have the same question.
It is highly probative on this court. But at the end of the day, Your Excellencies, that consistent standard is clear. And all respondent asks is to be evaluated based on what international law requires and not what applicant wants it to be. Thank you, and it was an honor to speak before this court.
Thank you. Thank you, Counsel. We'll now retreat to deliberate, and we'll return soon with our decision.
The Honorable Court is now adjourned. Counsel and spectators, please stay in the courtroom, and the judges will leave to deliberate.
Wow. Crank me up. Check, check. Check, check. Wow. 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 Just, wow. Just, wow. I mean, that was amazing. Good afternoon again. While the judges are deliberating, we have a couple things we need to get through, but before I do that, wow. Nicely done. I have the honor at this time to introduce the chair of the Board of Directors of the International Law Students Association, who is also the founding chair of the International Law Students Association, and who is, in less than a month, finishing his tenure as chair of the International Law Students Association. Please welcome Stephen Schneebaum.
Thank you. Well, thank you, Michael. And my friends, as you all know, the Jessup competition, now in its 67th year, like other such venerable institutions, has generated an extensive network of customs, all of them, of course, established through uniform practice and opinio juris. This talk, given annually by the chair of the ILSA board, is one of them. So let me start with the obvious. On behalf of all Jessup competitors, their supporters, their teachers and coaches and judges around the world, let me offer our congratulations to the two best Jessup teams in the world in 2026, the National University of Singapore and Ateneo de Manila. They have just shown us that they richly deserve their places in the final round, and whichever of them takes home the Jessup Cup, they are both excellent, and we are in awe of their diligence, their skills, and their perseverance. I also want to remind everyone of the incredible work done by the men and women behind the curtain, the staff of ILSA's executive office, and the volunteers who support them. This year's competition posed difficulties that we had never had to confront before, but unless you have been watching closely, you may not even have noticed. It is such a cliche to say that people deserve credit for working tirelessly, but here that expression is literally applicable. These international rounds would not have been the phenomenal success that we have all enjoyed this week without the extraordinary 24/7 efforts of our superb executive director, Michael Pyle. And I challenge those who follow me in this role to find more superlatives and more words of praise and more thanks to heap onto Michael and his incomparable deputies, Christopher Bonet and Roxana Nazari. And while thanks are being distributed, let me once again extend Ilsa's deep gratitude to the law firm of White & Case, who the firm's chair, Heather McDevitt, unfortunately could not be with us today, but without her support and that of everyone at White & Case, this week would simply not have been possible. We thank Heather and her firm for believing in Ilsa and for their singular dedication to the students for whom this organization exists. Now, the next tradition to which I now turn is an important but a sad one. Since the Jessup community is worldwide and multi-generational, it is appropriate that each year we take a moment to remember the members of our global family whom we have lost during this past year. Albi Chela and his fiancée were killed in an automobile accident in November. Albi joined the Jessup family in 2014. He represented Albania in the international rounds for 4 consecutive years, as well as in the European friendly rounds held in Hungary, Cyprus, and Austria. He was a true pioneer of the Albanian Jessup team, going above and beyond to ensure that the Albanian flag was always raised in Washington, D.C. throughout his years as a competitor. In 2019, Albi returned to coach the Albanian team, and in 2020, he served as a judge in the U.S. national rounds, regional rounds, that is, after moving to the United States to pursue his LLM at Arizona State University. He continued his legal studies at Cleveland State University College of Law and was on track to sit for the bar exam this coming July, when his life was taken from him and from us. Ivan Yaramchuk was also a pioneer of mooting and was a member of the first ever Jessup team from Yuri Fedkovich Chernivtsi National University in Ukraine, as well as that country's first ever Jessup summer school. Following his participation in 2017 at the national rounds, he remained actively involved in developing the university's moot court community by coaching teams, co-leading the Moot Court Society, and advocating for broader institutional support of student initiatives at Chernivtsi. Ivan was killed in combat while serving as an infantry medic, taking part in the defense of the city of Chasiv Yar in eastern Ukraine. I ask you all now please to rise and to honor the memories of Albi and of Ivan with a moment of silence. Thank you. And now, it is my pleasure to announce the topics of the Jessup problem for 2027. Those of you who have been here before know that what I will now tell you will be the only clue you are going to get until September about the problem that will obsess students around the world until we next meet again in April of next year. Ready? The 4 questions posed in next year's Statement of Agreed Facts are the following. Number 1, allegations of gender apartheid. Number 2, state responses to a mass influx of migrants seeking asylum. Number 3, sanction designations generated by artificial intelligence. And all of these in the wake of number 4, a coup d'etat resulting in a government whose status within the international community remains contested. That's it. Finally, I want to take advantage of your patience for just another few moments as I ask you to indulge me in some personal remarks. I have served as chair of this beloved organization for a total of 12 years since ILSA's founding as an independent entity in 1994. As Michael told you, I stepped down at the end of this month, and I am delighted to let you know that my successor will be my friend, Judge Andrew Holmes. I cannot think You kind of got ahead of me there. I was about to ask Andrew to stand up. I cannot think of a person better suited to assume this role. I'm confident that the entire Jessup family will welcome Andrew as he assumes its leadership. Let me ask Andrew, please, to stand. I don't think you've done that. And we all join in wishing him good luck. This, then, is my last opportunity to address you. It comes at a uniquely difficult and trying time for international law, and an especially difficult moment for students wishing to become international lawyers. The evidence does not need to be belabored by me. The news media are daily doing a more than adequate job at presenting the sad facts. Suffice it simply to reiterate Article 2.4 of the United Nations Charter. All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. Today, it seems almost quaint. Around the world, universities, probably including yours, are convening meetings and seminars and debates on the topic of whether international law still exists, whether it is worth studying, whether there still is, or even whether there ever was, a viable international legal regime. Whether the post-war era, with the prominence it gave to the rule of law, even when legal norms were honored in the breach, has given way to a new age in which, to quote the brilliant speech of Canadian Prime Minister Mark Carney in Davos, channeling Thucydides, the strong can do what they can, and the weak must suffer what they must. How far we have come. Not so very long ago, President John F. Kennedy of this country spoke in his inaugural address of, quote, a new world of law where the strong are just and the weak secure and the peace preserved. In 2017, Michael's predecessor as ILSA's executive director, Leslie Benn, welcomed Jessup competitors to Washington by reminding them of the words of Sir Edward Grey, Foreign Minister of the United Kingdom at the outbreak of the First World War. The lamps, he said, are going out all over Europe, and we shall not see them lit again in our lifetimes. Leslie cited those words to celebrate the progress the world had made. The lights had in fact been relit by international lawyers, and it seemed as though they would remain lit forever. Resisting the winds of change, fueled by international law. But to mix a metaphor, that bubble has burst. That enthusiasm is dissipated. That confidence is no longer sustainable. So what do we do now? How do you maintain the commitment to the rule of law that we see in this competition in the face of what we read or hear or see on our screens and in our communities every day? Or do we simply resign ourselves to despair? Every one of us will have to answer those questions for herself or himself. But let me offer a few suggestions. First, we must be confident and resolute in our belief in the rule of law. Only if the law is protected, honored, and observed can humanity achieve a measure of justice and equity. The only way to engender hope for ourselves and for generations to come. Lawyers have always been, and will always be on the front lines of this struggle. We have been the sworn enemy of tyranny and those who seek it since time immemorial. And for that reason, we have been targeted throughout history. Welcome to the battlefield. You are the reinforcements, and you are needed now more than ever. Second, advocating for the rule of law is a means to an end, not an end in itself. There are other avenues that some of you will explore in your careers and other opportunities that you may seize, using your knowledge of the law and your skills in advocacy to promote peace, including the peaceful resolution of disputes between nations. You may become diplomats or elected leaders. You may be professors who will encourage and inspire the generations that succeed you. You may become judges who, through wise decisions, will demonstrate that the law is not a rigid set of strictures, but a formula for achieving justice tempered by mercy and compassion. Third, it is okay to be frustrated, to be depressed, and to be angry. Indeed, it might well be said that if you are not angry, you are not paying attention. But you have to pay attention. When a world leader announces from his bully pulpit that, quote, "I do not need international law," you have to pay attention. You have to focus when the head of a powerful nation's war-fighting operations declares that rules of engagement dictated by the Geneva Conventions are, in his word, stupid. And even closer to home, you cannot ignore the fact that nearly 30 nations' Jessup teams, your colleagues, our friends, are not here with us in Washington. Their travel prevented by suspicion and mistrust, and for some of them, by war. And finally, it is not okay to remain silent. People, just like nations, will always disagree about the best course, sometimes deeply and for good reasons. But the rule of law will not survive if its defenders do not speak up. When the former president of the Republic of Liberia, Ellen Johnson Sirleaf, was awarded the Nobel Prize for Peace in 2011, she told all of those who love peace and justice, quote, to find your voices and raise your voices. When you do speak up, no one can guarantee that you will prevail. But I can guarantee one thing: you will not be alone. Look around this room right now. These are your colleagues in the struggle. Old and young, from every tradition and in 100 different languages, these are the people who will be by your side as you will be by theirs. The tests that lie ahead of you in your professional lives will be far more difficult than preparing for this competition. What we hope, what the International Law Students Association has attempted to show you, is that through this exercise, you can acquire the means, the tools, and the grit that you will need to carry the torch. Despair remains an option. Pessimism is omnipresent, and with good reason. But it is hard to imagine how anyone, having seen your dedication, having heard your performances this week, having watched as you found common cause and friendship with colleagues from every corner of the planet, can fail to have hope. But whether that hope is justified, I'm afraid, is now up to you. And so let me conclude with this challenge and with this wish. When days are dark, and when it appears that the international order is crumbling, remember the time you spent in the Jessup competition. Remember the people you met here and the things you learned here. Even when it is most difficult to see the light of Lord Grey's lamps, remember, they were not extinguished in 1914, and if you have your way, if you deploy your commitment and dedication to peace and to the rule of law as you have done here, they will shine on, despite everything, in 2026 and for decades to come. So thank you, good luck to you all, and let me now introduce Aditya Singh, a partner in the Singapore office of White & Case and a member of the ILSA Board of Directors. Good luck to you all.
Thank you, Stephen. Ladies and gentlemen, we have just witnessed exceptional advocacy from our finalist teams, but I want to take a moment to recognize every student who participated in the Jessup this year. You committed months of your lives to this competition. The Jessup demands the very best of you, and you delivered it. Congratulations. This year marks the 19th year of White & Case's global partnership with the Jessup. Over nearly 2 decades of this partnership, we have sought to celebrate the values that the Jessup represents: international cooperation, excellence in advocacy, and a deep and enduring commitment to the rule of law. 6 years ago, White & Case established an annual award to honor Jessup alumni who have made a profound impact on the legal profession and beyond. Now, Jessup alumni have gone on to become leading lawyers, judges, academics, government officials, and public servants, each playing a critical role in shaping a more just society. In selecting the award's recipient, we look for someone whose life and career embody those values, someone who began, as you all did, as a law student trying to argue a difficult case and carried that experience into something extraordinary. It is my great pleasure to announce that the 2026 White & Case Distinguished Jessup Alumni Award goes to Professor Jimena Fuentes. Professor Fuentes participated in the Jessup in 1990 as a student at the Faculty of Law of the Universidad de Chile. Professor Fuentes exemplifies the very best of the Jessup tradition. She has distinguished herself not only as a scholar and an advocate, but also a public servant and a diplomat of exceptional accomplishment. Professor Fuentes has represented Chile multiple times before the ICJ, including as an advisor on the maritime dispute with Peru, in the Bolivia v. Chile proceedings on access to the Pacific Ocean, and as agent in the Celala case. She has also represented Chile in the ICJ climate change advisory proceedings last year. As a scholar, she has taught public international law at multiple universities in Chile and abroad, and served as president of the Chilean Society of International Law. As a public servant and diplomat, she has served in a number of distinguished roles: as a deputy judge of the Second Environmental Tribunal, as Vice Minister of Foreign Affairs, and most recently, as ambassador to the United Kingdom. For everyone competing here this week, her example is a powerful reminder of what the Jessup can inspire. It is an honor to present the Whiten Case Distinguished Jessup Alumni Award to a member of the Jessup family whose career has brought distinction to our community. Professor Fuentes could not be with us in person to accept the award, but she has kindly shared a video message for us, which will now be played. Thank you.
I want to express my heartfelt gratitude for this award. On the 22nd of January, I received a mail from Elizabeth Black informing me that I have been selected as the 2026 recipient of the Whiten Case Distinguished Jessup Alumni Award. This news came as a fantastic surprise, and it means a lot to me because the Philip Jessup competition occupies a very important place in my life. And for that reason, I am very, very sorry that I cannot be with you in person today. I was a participant in the Philip Jessup competition in the 1990s, way back 1990s. And it is not an exaggeration if I tell you that this experience had a great influence in my future career as a lawyer and as a professor of international law. This was the first time I had the opportunity to experience a moot court competition, where knowledge of the law was only one aspect of the many skills that a good lawyer needs to display in court. The Jessup experience showed me that being a practitioner is an adventure, a real adventure into the complexities of real-life problems. And it requires more than knowledge about the law. It requires creativity, imagination, some actoral skills, in fact, a lot of actoral skills, intellectual curiosity, and an interest in the human condition. I enjoyed so much my experience in the Philip Jessup competition that I decided at that time that I wanted to work in the field of public international law. My first option at that time was to become an academic. And I was a privileged person because I wrote my thesis, my PhD thesis at the University of Oxford under the supervision of Professor Ian Brown. I wrote about international water courses. And when I went back to Chile to work as a professor of international law, I was lucky enough to work for my country with regard to a controversy regarding an international river. So life is also made up of these lucky moments. I ended up working for the Republic of Chile in 4 cases before the International Court of Justice. And later, I became head of the International Boundaries Department at the Ministry of Foreign Affairs. Then I became Undersecretary of Foreign Affairs. And more recently, I was the Ambassador of Chile in the United Kingdom. Looking back, I think that the Jessup competition was indeed a life-changing experience for me. And for that reason, I continue to work in the preparation of the Chilean Jessup teams, because I know that what you get to learn from this competition is much more than what you learn in the classroom. I'm sure most of you will become great lawyers. And let me tell you that I am convinced that today, more than ever, we need very good lawyers, good, honest, knowledgeable practitioners, because a rules-based order is our only opportunity to face global challenges today. Finally, I would like to express my gratitude to the International Students Association in the person of the Executive Director, Gil Pale. You have made a great contribution to international law. And I'm sure that my experience is not unique. I'm sure that all former Jessup participants will share my view that this competition is a life-changing experience. So I would like to end by wishing you the best of lucks in the competition. I'm sure that you will make great. And thank you very much. Good luck.
So while the judges are finishing up their deliberations, I have a number of people to thank. And Stephen mentioned the traditions. One of those is that I get to thank a lot of people. None of this would have been possible without a literal cast of literal thousands. I want to thank a few of them now. The first are our national administrators, national round judges, national memorials judges, and volunteers of all stripes who we don't see here. Some of them come as judges, but the bulk of their work is organizing all of those national and friendly rounds around the world. I'd like a round of applause for our national administrators. I don't know what led me to believe there's a camera over there, but that's to the camera. The Zhu Wenqi Award is given by the Executive Office every year to the outstanding national administrator or national administrators in that year. It rotates around depending on how the world changes. This year, the Zhu Wenqi Award, in part, returns home. Dr. Zhu Wenqi was the founding national administrator of the Chinese national rounds and led the Chinese national rounds from a tiny start at the beginning of this century to one of our largest national rounds. And so it is completely appropriate entering the third year after his retirement, a retirement that was well-deserved, but caused me a great deal of stress. How do you replace a legend who is literally the institutional wisdom of such a large competition? It gives me great pleasure, and I'd like to invite his school's Jessup team to come up and receive the award on behalf of our second ever Chinese national administrator, now entering his third year, Dr. Zhu Lijiang. China University of Political Science and Law. I had yes, I'm going to phrase it that way. I had a dream about 25 years ago, and yes, these are the kinds of things I dream about, that we would take all these tiny U.S. regionals and combine them into one giant U.S. national rounds. 150 teams all gathered in one place, rivaling even the size of the vaunted international rounds. The board of directors back in 2001 said that was insane. We had 12 regionals at the time. They each had about 12 teams. And then my predecessor, Amity Boy, tricked them into consolidating down to 6 super regionals, as we called them then. And then for financial and other trumped-up reasons, my other successor, Leslie Benn, managed to sneak it down to 5 or 4 or 3, and then I came back and said, well, wow, we're coming out of COVID, why not have 2 semi-national rounds? And then this year, for the first time ever, because, you know, what's the difference between 2 and 1? You know, it's such a small difference, and pay no attention to the slippery slope board of directors, all of whom are also Jessup judges, but this year, the dream came true. We brought all the U.S. teams into one competition in Atlanta, Georgia, and that, yay, Atlanta. It was awesome, especially in February. Nice, warm climate. But I want to congratulate and invite up here, I want to congratulate both of them, and I want to invite up here the only one who was able to join us this week, our first ever national administrators of the King and Spalding United States National Rounds, Jeff Brooks and Jenny Englander. Thank you, Reem. We didn't have her plaque 4 days ago. But the net is much broader than that, and the support network that ILSA and the Jessup competition have is much broader than that. I'd like to recognize at this time a couple of groups that are central to the success of this organization. I'd like to ask them to stand in place and let us express our gratitude. The first is my incredibly active and indispensable board of directors. Please stand. The second is the members of our All Rise Society, the donors that paid for so many hotel rooms and so many flights and so much of what we have around here. We appreciate your cash, but it's no coincidence that many of you are also the beating heart of our judging corps, of our administrators. I'd like to ask the members of the All Rise Society to please rise. I have a number of other categories, but I would like at this point to do one of my favorite traditions. It falls to the executive director every year in my sole discretion, sole and unfettered discretion, to indicate a volunteer either at these international rounds or around the world or someplace else who has done extraordinary work on behalf of the Jessup competition. We call this the Pamela M. Young Award. As you've heard all week, the drumbeat of there are teams who are competing from abroad. There are teams that can't be here, and how on and one of them even advanced to the runoff rounds. A month ago, 2 months ago, when we were trying to figure out what we could do to recognize them, we had to figure out who would do that. I mean, we figured, okay, there must be something like cameras out there, and we must have an FOJ who understands how those work. There must be something, some web or net or something we could use to connect our camera to their camera, and we must know somebody who knows something about that. And then we're going to have to babysit those cameras and those tubes so that we can actually hold these rounds. The recipient of this year's Pamela M. Young Award was the man who made all of that happen. You saw him on the second floor all week. He his job didn't exist in this competition a month ago, and all of a sudden, I want to do it again next year, Jeff. Come on up here, Jeff. Jeff Blackwell. The song goes, you don't know what you've got till it's gone. This year, this almost got a lot harder. Our judge's room, our judge administrator suddenly had a big case come up, and he said, I'm not going to be able to do it this year. So we cast about who else can handle these huge grids of names and everything else. And you know, we've got a great team. You know, you'll hear about them in a moment. But then about a week and a half before the international rounds, he said, okay, well, the case is gone now. I can come. And I know all of us, our hearts leapt. But he's not just the judge administrator. Anytime I need judges anywhere in the world, he keeps in touch with every judge. And so if I say, I need some judges, experienced judges, to practice Muda team in Botswana, or I need 107 judges in Atlanta, or you know, 8 in Vietnam. There's one person I call, and he's usually the last call I have to make, and that's why there's no question in my mind that this year's Pamela M. Young laureate is also Derek Moore. I told Derek to make sure that Jeff came. So Derek thought that he was here because he had to make sure Jeff was here. And just before the judges, I gather that they are almost ready to come in. So I would like to thank the amazing bailiff crew we have, led by Thais Neves and Amity Boy. Thank you very much. Larissa Rebello and our student directors, Tarazi Fung and Daniela, who ran the information desk and pretty much were the glue that held the entire operation together this week. Thank you all very much. In the judges' room this year, in addition to Derek, we had Anaya Palmer and Jenny Englander and virtually Jeffrey Brooks. And yeah. I'm sure you guys could have done it without him. You were doing great, but I do know there was a great sigh of relief when he came back. I'd like to thank all of our judges. I mean, come on, just that's all. That's our amazing. Thank you. When you graduate to being a judge, we put you in a cage. That's not to keep you out. I'd like to thank our incredible partners at White & Case. The competition has transformed in the 25 years that I've been associated with it, and so much of that can be attributed to the involvement of the world's greatest law firm, right? Come on, in our world, that is what you are. I'd like, yeah, yes. Here with us today, we have Jack Pace, New York antitrust partner and head of the pro bono practice at White & Case. Thanks, Jack. We have Aditya Singh, who you just heard from, and so many other lawyers here with White & Case who judged this week. We have Madeline George, Manager of Responsible Business, and the incomparable Elizabeth Black, Global Head of Pro Bono and Responsible Business. And then running around all week with social media and with the photographs and the tubes and the webs and the mucky mucks and the nicky nacks and the ticky talks. Ennio Rizzi, Everton McLean, Mimsi Mejia, Richard Hogue, Tony Natoli, Vince Oliver, and Durs Eliezer. Thank you guys very much. And finally, they do not get enough thanks. I am grateful every day that I'm involved with ILSA that I have the world's greatest team. I mean, you guys are good. Mine's better. Christopher Bonet and Roxana Nazari. Hi, Chris. I know you can see me on the camera. He's outside. With that, I'm told that the judges are now ready, so in a moment the bailiff will say, "All rise," and we'll find out what they thought of that amazing round. Thank you all very much.
All rise.
You may be seated. Good afternoon again. Congratulations to both teams. We're going to announce the results of our deliberations, but first I want to give my co-judges a chance to say just a couple of words about this experience.
Good afternoon. Buenas tardes. How are you? ¿Cómo están? It has been a real privilege to be here, and of course, firstly, I want to congratulate both teams for the extraordinary participation, performance, and rigorosity. I don't have enough words to recognize your hard work and your capacity, not only to prepare the speeches, but also to admit and to respond with flexibility to our interruptions, continuous interruption and questions. So I really admire you both teams, and I want to express not only my congratulations to the both teams, but to all of us who are in this room at this moment, because from my very first moment coming to this hotel and feeling the energy around international law, thanks to Jessup and the amazing people that organized the Jessup competence, I felt hope. Hope in the times where it's not always the feeling that we have daily. So thank you so much. I hope this experience, it is in my case, will enhance our love, our passion for international law, because I think in these times of crisis of international law, of crisis for human dignity, of crisis for nature rights. I also like to talk about nature rights, as the Inter-American Court has recently stated in the marvelous advisory opinion, and the right to environment as Jus Cogens International. So we are in times of crisis, but we are also in times of moving forward for international law, moving forward for protection of human dignity and nature. So I really hope that all of us, when we are back in our homes, will be with the same energy, fighting, if you allow me this word, for be good lawyers, taking into account and applying international law, not because we like international law, because it's our responsibility to know, to teach, to learn, to study. And I think this has been an amazing opportunity to learn, thanks to this problem, but it was not a little problem, but a huge, amazing, sophisticated, and really good problem to learn and to think all together. Thank you so much. Muchísimas gracias.
I also wanted to say congratulations to all of you who have been participating in the Jessup. I was going to say participating for the last week, but it's not been the last week, has it? It's been the last several months. Writing the memorials, taking part in the national rounds, probably hundreds of practice sessions, and then coming here to DC for the international rounds. I'm sure it's an experience that will stay with all of you. And one of the great things about the international rounds, in addition to everything that Judge Munoz said, which I totally agree with, but one of the things that I think is actually also really significant is coming in and seeing people from all across the world discussing and debating these questions of international law. So that's fantastic, and congratulations to all of you for getting here, for all the hard work. And I want to say particular congratulations to the two teams that made it through to the championship round. Really impressive advocacy from everyone. What I can say is that what you have done is much more difficult than actually appearing before the International Court of Justice. It can only get easier. You will not do this in front of as many people as you have done it. You will not have judges peppering you with questions. So this is as difficult as it gets, and you all did a fantastic job. So congratulations to all of you. Just to pick out a couple of things. just to pick out a couple of things that I thought you all did really well, and I'm sure that others in the competition would have done this well too, but which I thought you did particularly well. It's always a real challenge navigating between answering the questions of the judges and then sticking to your structure and coming back to the points that you want to make, and I thought that you all did that really well. So you responded to questions, you actually took time to try and answer those questions, but then moved as quickly as you could back to the arguments that you wanted to make, and I thought that that was really good. And then secondly, actually, the responses to the questions. Of course, we've come in right at the very end. Maybe some of these questions you got before, maybe others you haven't got before, but you know, it's a real compliment to all of you to be able to take the various questions, use the knowledge that you have to be able to answer those questions. So congratulations to all of you.
So I'm going to announce the results, but before I do, I want to talk for about 45 minutes. That's it. No, I just want to echo my colleagues' gratitude for the opportunity to be here and judge this championship round. It really, genuinely is a privilege for me. I want to thank the organizer, Michael, all the others, everybody who's worked on the competition, those who, the authors of the problem, for the work in making Jessup happen. When I was a law student, I participated in Jessup. I'm very proud to say, but I did not make it to Washington, so so I admire all of you who participated in these final international rounds of the competition. And to the finalists, wonderful, wonderful job. I echo everything that's already been said. What you have done, the way you've performed, and I mean this sincerely today, is at a level that superior than 95% of the lawyers in this world, and I mean that sincerely, in terms of oral advocacy. And so you're well on your way to being outstanding lawyers. And to everybody else who participated in this conference, in this competition, I'm sure you benefited enormously, as have I and my colleagues, I'm sure as well, from the experience. And so I want to congratulate all of you as well. Just a bit of reflection along the lines of what Soledad says. You know, these are really, really trying times, including for international law. And I hear almost every day from many of my colleagues, law professors, and certainly from a number of students that I interact with, is there still international law? Does it really matter? And I think what you all have shown is that, yes, one, there is still international law, and two, yes, it does really matter. And not just in a hypothetical sense, in the sense of a hypothetical problem, but the kind of problems that really exist in the world that can be addressed by international law. And the problems that you were addressing in this hypothetical reflect a lot of the problems and issues in the real world. And so the kind of answers and approaches that you brought to these issues can contribute in a concrete way, if not today, down the road. So thanks for the optimism that you brought to this event, for the hope that you've displayed and that really emboldens all of us. And I'm going to take that with me back to Boulder, Colorado. So thank you very much. And so with that, it's my pleasure to first announce the best oralist in today's championship round. But before I do, again, let me just emphasize how each one of you were outstanding, and we had quite a debate in trying to decide which one was the best among such stellar oralists, each of you. But we had to choose one, and the one we did choose was Tan Kai Han. it's my pleasure now to announce the winners of the 2026 Jessup competition. And the winners are the team for the applicants. Okay.
I declare the championship round closed. I will see you all this evening at the closing gala. Thank you all very much.